Hi, welcome to Authentic Ingenuity Entrepreneur. Today we will be dealing with episode 61. You have to bear in mind that this case that I've disclosed on my YouTube channel is basically before a forum of a court. So that's how I'm dealing with this case, because I'm representing myself. Today we'll be continuing with the interlocutory application, notice of objection for order to strike. The next data hearing was the 27th of February 2017. So basically I'm just continuing from the other episode, the same interlocutory application. I'm almost finished with this interlocutory application. This video will be mainly focusing on the next bit of evidence that I'll be walking you through. As you can tell, I'm actually reading from the actual interlocutory application that was submitted to court. This is a signed interlocutory application, and it was a sworn one before a registrar, so it is definitely a legit legal document in the courts. All right, so excuse me if I sort of like glance away from the camera every now and then. It's because I'm just referring to my notes. So I'll be just walking you through the substantial evidence. The next part of the evidence that you will be witnessing is around the background in regards to the family violence and the conversation that I had with Dr. John Joseph, the psychiatrist, in this matter. Why this information is relevant. First of all, before I get into the details, it has already gone through the court process. This is the evidence that I'm actually disclosing that has already gone through the courts. This portion of the evidence is around the part where Dr. John Joseph asked me about whether I was being suicidal, and then I went on to talk about the family violence back in 1998. Why is this evidence important? It is important because it was an incident that took place as far as 1998, so it was that far back in my medical records. However, the evidence that was that's actually in this medical evidence at this point in time, I'm just trying to prove a point in my medical evidence, just with the documentation evidence, substantial legal evidence that I submitted to the court, that my case is actually not family violence, but that my case in general has been cyberbullying within the workplace and public attacks. So basically what I'm trying to prove to the court is, just by documentations alone, there's sufficient evidence to prove that I'm a victim of cyberbullying and cyber attack in general, like as a whole, everything that I've gone through. What I'm walking you through is evidence that the judge has already cited or was presented to the court during the court process. We've just got to bear in mind this incident is family violence. So the only people involved in this incident are the people that I acknowledge, and the people that are actually in the document. That's the relevant information that's important during this incident. So this incident was during a period of time when I was married. I was actually married at this point in time to my ex-husband, and we had 3 children at this point in time. So why this information is relevant is because it has all the key components of who was involved at the time, all the parties that were involved, what hospital I went to, and the dates that took place, and everyone at that point in time that had anything to do with me, as far as the administration of the documentation, the doctors who wrote the report about what happened and why I was there and who signed it. And it even had the name of my friend who took me there, and her name was Dawn Sutherland, and she took me there, and then my sister picked me up afterwards. Why these information is really important is because I'm trying to prove that there's been an invasion in my privacy. There's been an invasion in my private life. So this is what I'm trying to prove. At this stage, the defendants legally is and should be the Ministry of Health. However, when this hearing first started off in the courts, it was against 6 doctors, and it involves, you know, the company now, Ministry of Health, because it involves different doctors and nurses, and they all got different scoops, but they've all had something to do with my medical records or to do with me. We've got to bear in mind at this point in time, this evidence is between me and my ex-husband at the time. We were actually married at the time. So this incident had nothing to do with his family, had nothing to do with his friends, had nothing to do with my friends, my family, and it had nothing to do with the workplace bullying, my work environment. It had nothing to do with the public in general. And what I'm trying to say is it's no one's business, but this incident did occur. So what I'm trying to prove is this is not family violence when everyone's involved in really private, personal incidents to do with my family. This interlocutory application, there were several other applications that were submitted and attached with this application. Other documents that was submitted that is important to mention and confirm, they were sworn affidavits and exhibits. So everything I'm mentioning or have mentioned are exhibits or were exhibits at that point in time. I also had on this affidavit and confirmed that I had an alias and that I had a name change. Along with this affidavit to do with the family violence, I had police reports and 111 calls that were made at different times when he was living with my ex-husband during this time. At this time, I also had a final protection order, and in this protection order, it had the name of the lawyer who helped me through the process of getting a protection order. In this protection order, had a tenancy order. At the time, we were living together, so I got to take over. He had to move out, and I got to have a place with the children. It also, on this order, it showed that I had full custody of our 3 children at the time, and their names were individually written on this final protection order. That also meant that no one else, for those that don't know what a protection order is, when a protection order is in place by law, it means no one, none of his friends, none of his family, no one is allowed to use my children or anybody in my family or in my environment to get a message to me, like indirect. That's what a protection order is to stop mental abuse, psychological abuse that do take place in family violence from time to time. But that is what a final protection order does. So I actually made that final. To this day, it's still legal in the courts. But the people named on that final protection order was myself and my 3 children. They were named. And in this application, I had submitted my divorce paper as proof that we divorced, and I had a name change. I also had the birth certificates of my 3 children to prove that, that's their father and I'm the mother. Also on this documentation, I submitted my driver's license. I submitted my New Zealand citizen documentation because I'm legally a New Zealand citizen. And I also proved to the court before I got my job working for any government agency, I was a single mum, but I had taken out a student loan and decided to do studying, in a student loan to actually get some qualifications, documentations behind me. And when I did an advanced certificate in business administration, so I had proof of that evidence in this sworn affidavit. Everything was submitted. Why I did that was because I knew that my background was very complex, and me being adopted and all the rest of it. So basically I had to put in those documentations just to prove to the court, black and white, who they're dealing with, a bit of background about me, which is important. And not only that, I was representing myself. These documents, I can confirm, were submitted in this interlocutory application. Judge at the time was Judge Chalice. Just another piece of evidence as far as the family violence in regards to the evidence that was submitted to the courts. Now, as far as the family violence, I also submitted documentations and support just to let the judge know that it was in regards to my ex-husband at the time. He had mental health issues. He was under the mental health care, and all this information was relevant to how serious my situation was for me as a victim and as a single parent at this point in time. All that was submitted to the court as supporting evidence, of substantial evidence to prove that my background as far as family violence at that point in time was very serious, and was also the cause of action why I ended up trying to commit suicide. And that was way back in 1998. I think it's important to mention that every single judgment that was made, it was all appealed. However, those documents should have remained with the courts during the whole process that it went through the courts to all the other jurisdiction, as far as, because that was submitted at the district court, then it went to the High Court, and then it went to the Court of Appeal, and then it went to the Supreme Court. And then I tried the commissioner of the Judicial Code of Conduct. Basically what I'm proving to the court, that I've tried everything. And what I was trying to clear, obviously, is to get the record straight about my personal profile. So all these legal documents are actually the key components of the evidence and the background that should be satisfactory for the court for me to be able to go through the normal process of getting a fair hearing. I felt that this portion here that I actually highlighted on this legal document before the judge, I felt it was important and vital at that point in time for the judge to listen to the recording, and also just that portion where I felt that he had put words in my mouth, because at that point in time, before or leading up to that meeting that I was referred to by my family GP, I was not suffering from depression or anxiety, or I wasn't, as far as mentally and spiritually at that point in time, I was still very in a soundness of mind. The reason why this video CD was actually important as evidence, because it was an exhibit, it was submitted as an exhibit to the courts, and it was also transcribed by myself with my phone. So this evidence was evidence for the court, for the judge to actually listen to. The reason why it was important, because the whole video itself, I'm basically walking the psychiatrist through my historical cyberbullying that I was subject to. And so basically I was just, if you just listen to if the judge had listened to the CD, it was really important. It was like just a normal conversation that you'd have with other people, but basically the things I was talking about were actually true facts. And I was talking about, the cyberbullying. I mentioned some workplace issues, even mentioned names. But in saying that, I did submit supportive evidence that I'd actually lodged the protected disclosure to the different agencies that were involved at that time. This includes my employer. Back in 2010. That includes the police, that includes the IPCA, that includes the commissioner, and that includes the union, PSA, and my employer, as already mentioned. So this protected disclosure itself, all the evidence that was submitted at that point in time became exhibits for the court hearing during that time. So this CD, basically I was walking the psychiatrist through all the key issues that I was going through as far as the protected disclosure and all the complaints. And basically I was sent there by my GP just to get a medical certificate extended, and I even submitted that evidence as an exhibit. The reason why my GP referred me to that hearing was purely just to get a medical certificate extended for the purposes of the WINS benefit, because the doctor had actually my employer had medically terminated me. I now no longer, at that time, didn't qualify to go on a job seeker's benefit. I wanted to get straight away into the workplace, but then because of the medical terminated decision that was made by my employer at the time, I wasn't able to go on a job seeker's benefit. However, I wasn't even able to change my benefit to a job seeker's benefit until that medical terminated decision was first cancelled by my employer. But all these things took time, so I had to get me a lawyer while I went through the employment process, just to verify the reason why I was at this employment was purely just to get a medical certificate extended so I can still get an income, because now I no longer had an income. I was basically forced to go on the benefit. I wanted to be able to find another job immediately and go back into the workforce because I wanted to work. And of course I didn't want to be on the benefit, but then I was like in a real trap situation. I had no choice but to go on a benefit while I sorted all these issues in court, or go through the court, the court process and the court procedure to have this medical terminated decision cancelled. Assessment and the damage that it did not only to my reputation, but all the things that I had to go through at that point in time. And when I did go to see the psychiatrist, I did tell him that that's the reason why I was there. My ex-husband and I, we are friends today, but he hasn't had anything to do with the children and the upbringing of them due to the circumstances in the background, quite obvious that I've already mentioned. But he has actually moved on, and at that time he now has like a 13-year-old daughter. So what I'm trying to say is, although people are trying to create family violence, my case is definitely 100% not family violence, but it's definitely been an illegal project by whoever is behind the scene controlling and manipulating and then switching. I've really gone through the process of proving that the doctors didn't qualify. The doctors had operated outside of their scope, or they've breached their contract, and not only that, they had no medical evidence. So I've already gone through that through the courts. It's just basically just finalizing the court order, and because the judgments are unlawful strikes, that's what it's called in the court. And so that error needs to be corrected, and basically only I can actually clear that accurately because it's my profile. So we're continuing with the interlocutory application, notice of objection for order to strike, and the next date of hearing was the 27th of February 2017. So I'm just continuing on reading with this application, continuing from episode 59. I'll be reading the evidence. New evidence submitted. 1. Mental health assessment dated Thursday, 4th of February 2016, transcribed by Minna Crichton from her mobile phone. 2. The recording of the meeting. The plaintiff would like to submit the recording of this meeting and would like it to be heard in court as part of her evidence. Number 3, affidavit of Minna Crichton. Conclusion of the facts and supported evidence is that the defendants had no sufficient grounds to enforce or use the Mental Health Act, Compulsory Assessment Treatment Act 1992 on the plaintiff. There has been serious miscarriage of justice, injustice and abuse of authority, and the defendants have not acted on good faith. I'm going to be going through the interlocutory application to enter a summary judgment. So this interlocutory application to enter a summary judgment was a separate interlocutory application, but I have entered it in this application to notify the judge that I've submitted one. It was a sworn legal document before a registrar of the courts. Now I'm just going to continue reading. The plaintiff is within her rights to apply for an interlocutory application to enter a summary judgment on the following grounds. Number 1, the 25th working days had elapsed and twice the defendants were served with the notice of proceedings and a statement of claim. The plaintiff has followed the district court protocol procedures according to the district court rules and confirmed with the case officers involved and management. A. Exhibit 4D, an affidavit dated 19th of February 2017, email dated 13th of July 2016, Lyle to Minna. So this email is actually the DR that was dealing with my case at this point in time. So what I've actually copied and pasted on this affidavit was our correspondence as we were corresponding during the process of my case. So I'll continue reading. Hi Minna, you can now serve the statement of claim, notice of proceedings, and list of documents on the other parties. These documents need to be served within a year of you filing them. Once they are served on the defendant has 25 working days. If they are in Australia, 30 working days to file a defence if they wish to. B. Exhibit 4, bracket C, page 5, affidavit dated 19th of February 2017. Email dated 17th of August 2016. And this case officer was Steve McHugh, and he responded to one of my emails, also confirming the actual court protocol and procedure as far as the notice of proceeding. I'll continue reading. So this email is from Steve McHugh to myself. Greetings. 25 working days need to elapse as per service documents. If defendants file defence within those allowed 25 working days, then matter will be scheduled for case management conference. If defendants take no steps to defend the matter, then you can apply for judgment. So that's why I applied for a judgment. This application here that I've put on this interlocutory application to let the judge that there's one submitted. So that's the reason why I submitted the interlocutory application to enter a summary judgment, because the counsels had elapsed and I met that criteria for a judge to actually make a summary judgment automatically. So I'll continue reading. 3. The defendants were served twice with a notice of proceedings and statement of claim. A. The first one was served on the 15th day of July 2016. And B. The second was served on the 1st of August 2016, amended notice of proceeding and statement of claim. Number 4. The interlocutory application to enter judgment and affidavit to Crichton dated 6th of September 2016 clearly states a background of the defendant's reasons for relief. So what I've actually asked the judge at this hearing, whether she could enter a summary judgment, because according to the laws, I automatically now have that right to have an interlocutory application, because the counsels or the defendants, the counsels failed to actually lodge a statement of defence against my application. I can confirm and I can verify that during the whole process, since this case was pending in court up to December 2018, the defendants or the counsels on the behalf of the defendants did not submit a statement of defence against my claim. But in saying that, judge did make an order on her judgment, did note in her judgment that the counsels were to make a statement of defence against my case. However, that never happened. So to this day in the court, the counsels on behalf of the defendants, they have not submitted any defence. However, according to the district court rules and the laws, there is a procedure, and it actually still exists today. And this year is January 2022. Because I've had to use a system because of my case, I have noticed massive changes in regards to how you lodge civil cases. They've made a lot of changes. However, I can confirm and verify these laws and these protocols here, they still exist in the legislation. So even though this happened in 2016, but this is just confirmation, what it actually means, I've actually won my case, all right? The counsels and the defendants did not defend their case because they had no evidence. And that's what a civil case is all about. So that is what says on this legal document. I will now continue on the same document, but I will just going down. So I just wanted to go over the right to interplead. Now this here was also on this document. This was more like a real urgency, like you're pleading with the court to make an order because my liberty was at stake and there were so many other things behind the scene that was going on, you know, as far as my liberty was concerned.